We are President Case 18 CR 001208, State of Ohio versus Jasmine Hill. Ms. Hill was placed on community control sanctions of this court back in November of 2019. There have been, since that time, 3 motions to terminate community control sanctions. A 4th one has now been filed, and we're present. 4th one was filed a year ago. Ms. Hill has been arrested on that at this point, and we're here for the probable cause hearing. She is in court, and she's with her attorney, Ms. Lauren Tuttle. Ms. Tuttle, what's the defendant's plan in regards to the probable cause hearing?
Your Honor, Jasmine wishes to waive her right to both the probable cause and final hearings and enter a plea of guilty to the violations.
Thank you. Ms. Hill, you've been charged with violating the conditions of your community control sanctions. Specifically, there are 3 alleged violations. The first is a Rule 3 violation, which requires you to report at such times and places as directed by your probation officer. And it is alleged that you failed to report to your probation officer as scheduled back on June 9th of 2022, and you haven't reported since that time. It's then alleged you violated Rule 8. Rule 8 prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged that you overdosed on fentanyl back in June of 2022. The third violation is a Rule 11 violation, which requires you to comply with all special conditions set forth by the court. You were ordered at the last probation violation hearing to reside at a sober living facility through I am in transition, and that you failed to complete that sober living program. Now, you have the right to have 2 hearings regarding these allegations. The first, what's called a probable cause hearing, which is a hearing where the State of Ohio will be required to present some evidence that would suggest you probably committed these violations. You then have the right to have a final hearing on the merits, and that would be another day and time to give you time to prepare if necessary, but that's a hearing where the prosecutor, State of Ohio, will be required to prove the actual merits of what they're alleging. Now, you could have either or both of these hearings, but you can also waive both hearings and plead guilty to the violation. And your attorney has indicated, as you just heard, she believes it's your desire to waive both hearings and plead guilty to the violations. Is that correct?
Yes.
Before I can accept your waiver of the hearing and your plea of guilty, I need to make sure you understand the potential penalties and consequences you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to a total of 5 years. I could impose more restrictive sanctions against you, including more jail time, or I could terminate your probation and send you to prison. If I did that, it could be anywhere between 6 to 12 months in prison. Do you understand all the potential penalties you face if you are found to have violated your community control sanctions?
Yes.
Well, having been so advised, what do you want to do at this time? Do you want to have either of these hearings, or do you want to waive both hearings and plead guilty to the violations?
Plead guilty, please.
Very well then. As to the first violation, which is a Rule 3 violation for failing to report since June of last year, what is your plea to that?
Guilty.
As to the Rule 8 violation for having used fentanyl last June, what is your plea to that?
Guilty.
And as for the Rule 11 violation for not completing the sober living through I am in transition, what is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty to the 3 violations. Ms. Tuttle, is there any reason not to proceed with sentencing?
We're prepared, Your Honor.
Is there anything you'd like to say on behalf of your client at this time?
Yes. Your Honor, the past year has been a real growing experience for Jasmine. As noted, she did have an overdose last year. That was an intentional overdose. Jasmine was off of her mental health medications. She was attempting to take her own life. She was in a very dark place. and she sought help after that. She was able to be revived by the hospital staff, and she reports to me that she was taken to inpatient treatment at Ethan's Crossing. She spent a long amount of time in treatment there, she reports to me, before she was moved to a different facility for an eating disorder that she was treated for about 3 months. After that, Jasmine did return back to residential treatment. She's been working with I'm in transition for quite some time now. She didn't complete that sober living last year because she went into the residential program through Ethan's Crossing. She's been working on herself. She's been working on her sobriety. She's been engaging in medically assisted treatment and receiving Subutex. She's been taking that through a daily pill form. Since she's turned herself into the jail, Jasmine has been withdrawing from that medication. I know it was her hopes to be able to go back to residential treatment. IIT has talked to both the probation department and my office about the fact that Jasmine was in treatment in their facility, that they were able to take her back. They do have her bed set and ready for her. I think they anticipated that she would be returning to that bed. Jasmine asks that the court will consider that as an option, but understands that this is her 4th probation violation. She understands that she's had the opportunity at residential treatment. So if the court is not amenable to keeping her on community control, she would request a prison term in the amount of 9 months to allow her to be able to continue with her treatment, but to be punished for her actions and her conduct for not reporting to the probation department and not addressing this warrant sooner. Thank you.
Ms. Hill, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
I'm trying to get my life on the right track. I've been seeing my kids. I've been doing like all the right things besides turning myself in, and I just wanted to turn myself in to get that out of the way. So I had a clean slate. I just want to be doing the right things with my life. And I just want to get all this out of the way. Thank you.
Thank you. This court reviewed the original pre-sentence report and investigation, and along with Dr. Rinsberg's original assessment, I've considered the particular facts and circumstances of the underlying offense, the nature of that offense. I've considered everything said here in open court. I also considered the defendant's history here on probation with this court. This is all considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. I'm going to incorporate all the findings I've made throughout this case regarding the seriousness factors and the recidivism factors, with the additional finding, again, that the defendant has failed to comply with previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. At this point, when I consider all this information, I don't see how I can possibly make a finding the defendant's amenable to available community control sanctions. I've given you every opportunity and break I could, Ms. Hill. This is your 4th probation violation. To make matters worse, you've been gone for a year on this last one. You say all these things you've done, and maybe you have, but I don't have any proof of that. I have no idea about any of that, and that's what probation's purpose is. It's to supervise individuals, to provide the court and keep the court updated on what's going on. If I would just rely on probationers to tell me they've been doing their meetings and getting their treatment, I wouldn't need a probation department. But obviously that's not going to happen because believe it or not, what most probationers tell me is not really accurate as to what occurs. And you don't get to pick and choose how this is going to work. But I've given you many opportunities here, and there's just no more. There's no more I can do. At this point, you're not amenable to community control sanctions. Prison's consistent with the purposes and principles of sentencing. Therefore, it'll be the sentence of this court that your probation be terminated. You'll be ordered to serve a term in prison of 10 months. You'll get credit for 224 days you've already served. I need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another, in this case, 5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence here at this time. Offense ordered to pay all costs. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Ms. Tuttle, is there anything else for the record at this time?
No, Your Honor, thank you.
Thank you.
All rise.